So why do I keep giving away all my secrets? Sometimes I ask myself that, and the answer is always the same. It's because the law venture community is absolutely incredible, and I plan on taking it to the next level with this particular video by sharing my secret sauce to dominating depositions. So if you're preparing for a deposition, this is the video. This is the one that you need to watch. But before we dive in, you need to watch this intro. Welcome to Law Venture, a channel devoted to lawyers and law students. My name is Jarrett Stone. I'm the owner of Stone Firm PLLC, and today I'm your guide talking about deposition preparation. A mouthful to say, but it's probably even more cumbersome to actually have a successful preparation so you can go dominate that next deposition. But before we talk about the 5 steps that you need to take in order to prepare for your deposition, let's get oriented here, because right now we're talking about the stage right before you go take someone's deposition, the preparation stage. That should be obvious at this point. And for those that are watching this on YouTube, you need a little extra orientation here. First things first, obviously subscribe if you haven't already, and then be sure to hit the like button down below. In doing so, not only does it support the channel, but it helps helpful videos like these to rank higher. That way it can reach more people. The more people that it reaches, the more people that Law Venture can help. So it starts by hitting that like button down below. But if you are on YouTube right now, after you've done those things, then I'll slide a link above so you can go check out this video in its native format. What I mean by this is that this is just a single lesson in an entire course that's for free and available over on lawventure.com. Okay, so I'm especially excited for this video, and this probably is a long overdue lesson in this particular deposition course. The reason why I've put off releasing this course in the last few weeks is because in the last few weeks, I've been taking depositions. So I wanted to make sure I was primed for this video, and I was going through my preparation steps that we're gonna talk about in this video. That way I knew exactly what was working and what wasn't working, fine-tune, tweak what needed to be tweaked, use that in the next deposition and the next, and then eventually have something that I'm very confident in so I can present it to you in this lesson. But time out real quick. Here's my disclaimer. In this video, we're gonna talk about strategies and we're gonna talk about principles. Strategies and principles tend to be a bit abstract. And so if I'm talking about something that just not really sure on how it applies to your particular case, then don't worry, I plan on providing some examples in this video. That was poorly timed. So I plan on in this video providing some degrees of examples for you to kind of make sense of the strategies and principles that we'll be talking about in this lesson. But I'm not gonna go too into the weeds with examples. And so what I plan on doing is releasing a complimentary deposition course that has specific examples that applies the principles in this course that you're going through right now. This course is intended to be, again, the strategies and principles, and then the follow-up complimentary course is going to take these strategies and apply them in a very real case example. In fact, in the last month and a half, I've been saving prior depositions that I've taken in order to potentially flip those into courses for Law Venture's benefit. There's a strategy here and it's slowly coming together. Emphasis on slowly, but it's coming together. So what I recommend you do, if there's a point where you just kind of aren't really understanding the application of a strategy or a principle, then go down in this particular lesson and click the link that'll take you to this complimentary course. That way you can see the principles in action. But I will say, the course is coming after the recording of this video. So if you're on the ball, if you're watching this lesson soon after it was released, there's a chance the course isn't available. I'll see if I can put a link down so you can register for the course and get notification ASAP as soon as it's released. That's a different acronym, but you understand what I'm talking about. Okay, at this point, you're on lawventure.com, you're watching the lesson, you're ready to dive in, so let's do just that. So let's get started with the 5 steps by obviously starting with step number 1. The first step is that you need to know the elements of the case and you need to know the story. So step number 1 is no easy step. In fact, it has some subparts that we need to break down one by one. So what you need to do is understand, know, and internalize what your client's claims are. And just as a reference point, what I'll be doing in this lesson is kind of taking the position from the plaintiff's lawyer position in a civil case. If you're taking a deposition in a different scenario, you can apply the same principles, but for the sake of providing examples, it helps if I'm just staying on the same exact page and the same exact perspective. So in this situation, when it comes to knowing and understanding your client's claims, in this situation, I would go look at the operative petition, meaning the petition that was last filed and is currently in effect, to figure out exactly what my client's pleadings are. I know the thought is, well, Jarrett, I was the lawyer who filed the pleadings, and so I know exactly what they are. Again, you always want to be safe, and so I recommend that you go have a quick refresher, because this probably isn't your only case. Make sure you're understanding what all is being claimed in this particular case. That way you're not confusing other facts from other cases and other scenarios. And once you understand the claims, you also need to understand the elements for the claims, meaning what in particular needs to be satisfied for the claims to ultimately be proven. And this is so important. So what I like to do during step 1 is, as I'm going through the operative petition, is write out what the claim is as a header, and then under the claim, write out what the element is, and then move on to the next question. How can this witness help me prove these elements? And overall, how can the witness ultimately help prove the claim itself? Okay, I told you I'd give you an example, so here's one right here. Let's say in this example, I'm the plaintiff's lawyer representing the plaintiff in a car wreck case, and the deposition that I'm about to take is of the defendant. So in this situation, what do? Step 1 says, okay, let's go and look at the pleadings of plaintiff's petition that's on file. I take a look at it. I see negligence is one of the claims. So let's flesh out negligence, and we'll do it for all the claims, but for this particular example, let's flesh out negligence. Negligence has a series of elements that need to be satisfied. So I want to list those out underneath the umbrella that is negligence. And I see 2 elements that stick out. Element number 1 is that a duty existed, and element number 2 is that the defendant breached that duty. So what I'm thinking at this point, what I'm kind of formulating as a game plan, I haven't really, written down a script at this stage, but I'm asking myself, okay, how can the defendant's testimony help satisfy these elements? Well, let's say in this situation, the defendant didn't use a blinker. So I'm formulating this idea, and it's like, yeah, I can get the witness, the defendant in this situation, to admit and concede the fact that the defendant needs to use a blinker. In other words, the defendant has a duty to use a blinker. That one right there, especially if you're relying on a statute or a handbook, pretty simple. Let's move on to the next element, okay? That the defendant failed or breached the duty to use the blinker. Well, if I can get the defendant to admit that the defendant didn't use the blinker, then boom, check that element off. And this is concessions, I'll say. The defendant is conceding elements to their own case. This is a little bit more powerful than if a witness said, yeah, the defendant didn't use a blinker. So I want to go through each and every claim, and in doing so, go through each and every element. And as I'm kind of formulating this game plan with this particular witness, in this example, the defendant, I'm kind of maybe writing off on the side, okay, maybe ask questions about this, maybe ask questions like that. But I'm not writing the script just yet. That's for later. We're gonna kick the can down the road and move on to the next subpart here. We need to cover our basis by doing the inverse. We've looked at the plaintiff's pleadings. Now let's look at the defendant's answer. What is the defendant alleging? What is the defendant doing to deny this negligence claim and any other claims that are out there? So at this point, it's just simply rinse and repeat. Just like we did earlier, what you need to do at this stage is write down the umbrella of the claim. For example, if there's an affirmative defense of some sort, which then puts the burden on the defendant needing to prove that affirmative defense, then What are the elements to that affirmative defense? Is the defendant claiming that plaintiff was negligent? Does the defendant have to prove negligence? And if so, write down the elements of negligence and then start asking yourself, okay, how can you use the defendant's testimony to disprove those elements in order to favor your clients? But I'll also maybe recommend taking it a step further. Ask yourself, how can the defendant's testimony maybe prove these elements if things don't go the way you expect? You kind of need to prepare for the worst. And so in that situation, figure out, okay, they need to maybe get testimony elsewhere, or maybe the defendant needs to say this and that proves that element. If it's a big element, then you may want to try and frame your outline / script of your deposition, which we'll talk about later, in a light that helps really make it harder for the defendant to prove that element. So again, we're writing down little notes, little thoughts as we go along here, but at this point, we're starting to formulate a game plan. And part of that game plan requires you to think 3 or 4 moves ahead. If the other side is playing checkers, you need to be playing chess. You know how the saying goes. What I mean by this is, as you're going through these elements of what needs to be proved or disproven, then you need to start figuring out, okay, beyond this deposition, how can the elements be proved or disproven? And part of that is, okay, how is particular evidence going to be admissible at trial? Can you do the groundwork now during this deposition to help establish at trial that evidence is admissible or isn't inadmissible? I don't know. I got wires crossed my brain there for a second. Along those lines, you may think, okay, what if, for example, certain testimony, certain facts can only come out through the defendant hiring an expert? In that situation, the only way the expert is going to have any type of foundational knowledge in order to opine and give that expert opinion is if there's actual credible evidence to base the expert's opinion on. I think that made sense. You may need to rewind the last 5 seconds. So, in order to take that expert out of the equation, off the chessboard, then you may need to ask questions to show that this defendant doesn't actually have credible knowledge that an expert can base an opinion on. And so again, at this stage, you're starting to formulate a game plan. You're starting to formulate, the questions that you want to ask in order to build your case up in trial or to take weapons away at trial from the other side. This also takes me to another point. You should always be wondering, how can you simplify the case to your advantage? Or maybe you have a weak case and you want to complicate the case as much as possible. Think about each option depending on your situation. For example, in the plaintiff car wreck situation, a lot of defense lawyers and defendants, for whatever reason, plead that a sudden emergency ended up happening. And as a result, because of the sudden emergency, that's why the wreck occurred and that's why negligence doesn't exist. And then in the deposition, you ask a question like, well, were you in a rush? And the defendant assumes that you're trying to paint a picture that the defendant is racing down the road or wasn't paying attention because they're on a rush. So they try and play it cool, but internally they're on the defense and they say, no, I wasn't in a rush. And then the follow-up question being, okay, so there wasn't like an emergency that occurred all of a sudden. The defendant, as a layperson, is still probably thinking that you're trying to paint a picture that the defendant was rushing, and so they're probably going to say, no, there was no sudden emergency in that situation. So if that's an affirmative defense that the defendant doesn't really know that he or she pled, then you were just able to accumulate information and ultimately testimony that leads to that actually being a pretty bogus affirmative defense because the testimony says otherwise, coming from the defendant himself or herself. And so maybe you want to simplify the case by filing a motion to get that affirmative defense thrown out. That way, the less that's presented to the jury, the less complicating factors that are involved, and the jury can focus on what's important. Again, figure out what's going to work for your situation, figure out what your strategy is ultimately going to be. But part of that is thinking ahead. Don't just focus solely on the deposition that's in front of you. You need to try and put the pieces together and use the deposition in order to do that. At this point, you've gone through all the pleadings for both sides, and so you have an understanding of the technical aspect of your case. Technically speaking, this needs to be proven or disproven, but that doesn't really convey very well to a jury. Juries are sold or they're convinced by stories. So part of the equation at this point and during step number 1 is starting to formulate the story that you ultimately want the jury to hear. And so you kind of have to start building your characters at this point. If the other side is the defendant in the car wreck situation, what kind of character, what kind of role is this defendant going to play in the story that you mention and tell during opening statement, then ultimately show and prove during closing argument? And so as you're going through the facts, as you're going through the discovery and the responses and the answers and the objections, start trying to develop the story and start trying to develop the character. Is the defendant someone who is going to act like they don't know anything and everything? Maybe in that situation, the story is the lawyer is the one who is really calling the shots, and this is a lawyer-driven defense, and the defendant doesn't really know what she's doing. Or is the defendant really flip-flopping on the story? Is the defendant not credible? Is that the kind of character that you're trying to develop? And that all, again, begins with your deposition. Don't start trying to tell the story or even formulating the story right before trial. That's not going to work. And in fact, if you take all the precautions and you use the strategies at this phase during discovery, but in particular with your depositions, if you can accomplish things and execute the way you need to execute in order to go kill it at trial, the irony is you most likely won't be going to trial. You most likely will have built a really bulletproof case. I say really because it's ever 100% bulletproof case. I don't know, but you've built an incredible case, and most likely the other side is probably going to want to settle. So at this point, start building that story, but do the inverse as well. I want you to also see if you can get a sense of the other side's story. Is there a bad fact involving your client? Because most likely there's some bad fact to some degree, or the case already would have settled, that the other side is really going to hone in on. The other side is really going to try and blow something out of proportion. Well, that's probably going to be part of their story, and they're probably going to really indicate in their discovery responses and answers what kind of character is your client going to be. So your goal here is to look and think about what both sides going to portray, and then try and build the character, or maybe change your client's character through the defendant's deposition using the same example. So this next portion that I'm about to say is so important, and I'll be honest with you, I probably won't reiterate it later in this video, because it's really going to be something that you just have to store in the back of your mind and then incorporate it where you need to incorporate it. Unfortunately, since there are so many different situations that could be going on with deposition preparation, there's no way for me to say, hey, this is exactly when you need to apply this particular piece of advice. All that to say, pay attention to what I'm about to say, because it's going to make your life a whole lot easier. We're talking about stories, and unfortunately, if you have a bad deposition, then the other side can start kind of changing the story a little bit. And in doing so, if your deposition doesn't pin down the other side to that story, then they're going to change it all day, every day, and you're not going to have the ability to call them out on this changing story. What I mean by this is what you need to do is really with your questions, pin them down to the position that they're taking. And so this requires both the affirmative questions and the negative questions. The affirmative being, for example, you're taking the position that my client is 100% liable or responsible. And if the defendant in that situation says yes, okay, so that affirmatively shows that the story that's going to most likely be portrayed is that my client is 100% at fault. So let's, figure out how we're going to overcome that. On the flip side, let's talk about the negative. There are certain aspects that may end up changing the story. If the defendant starts adding affirmative defenses before the pleading deadline, which may be way down the road. And if there are different affirmative defenses, then the story may end up kind of changing and pivoting, especially if the defense lawyer in this situation gets a sense of, okay, This deposition, while it wasn't perfect, it was pretty good, and I can kind of see where this plaintiff's lawyer is going. So maybe we got to pivot our approach a little bit and kind of massage this story so it works a little bit more in our favor. So what you need to do in the negative is to start flushing out during your deposition. Okay, but you're not claiming this. You're not claiming that. You have no issue with this. You have no issue with that. And then as the defendant or the witness that you're deposing says, correct, yes, that didn't happen. No, I'm not claiming that. Then they can't change the story by eventually going and claiming that. Well, I guess they can, but if they do that, then it's not going to look good because that shows the flip-flopping and that makes them seem less credible because it's like, oh, well, 6 months ago when we took your deposition, you were pretty clear that you weren't taking this position. But then after we took this deposition, 3 months later, right before trial, you started taking this position. And then it's like, yes. And then the jury from their perspective is like, well, that's weird. Everything that we just talked about, that's all step number 1. We have 4 more steps to talk about. This step number 1 though, super important, super critical. Don't make assumptions on what the pleadings are. Don't make assumptions on what the elements are. Make sure you know those and you have them down. That way you can go dominate the deposition and then also move on to step number 2, which is know the purpose of your deposition. Look, you could say that the surface level purpose of a deposition is to just get favorable testimony on the record so you can ultimately use it to go win at trial. Blah, 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 super boring. We want to take things a step further here on Law Venture. We want to be strategic. We want to be very calculated. We want to play chess. And to do that, there are 2 strategies that you need to consider. The first strategy is to use the deposition for the purpose of just collecting puzzle pieces. So for me in my practice, I typically use this collecting puzzle piece deposition purpose strategy thing, which is a term of art that I will be trademarking soon. So don't steal that one. But I typically take this approach of just collecting good facts, good testimony, and then putting it in my back pocket so I can ultimately use those good facts, good testimony in the motion work that's heavily involved with class action cases. So with this approach, as I'm collecting puzzle pieces during the deposition, I specifically and strategically don't put the pieces together during the deposition for the other side to see. Instead, I just put them in my pocket and ultimately use them either in court or on paper with a motion or a response of some sort. That way, the other side isn't really clued in on exactly what I'm doing. I'm hiding the ball to some degree. And the point here is I don't want the other side to finally understand where I'm going with the particular puzzle pieces I'm collecting and then try and file some like sham affidavits, doing damage control saying, while the testimony said this, the question wasn't super clear. And so in reality, what the deponent or what the witness or the rep was supposed to say was actually this. Instead, again, hide the ball, collect the puzzle pieces, put it in my back pocket, file the motion, and then if the sham affidavit comes in response to that motion, then it's like, oh wow, that was a major convenience that it just happened to pop up as testimony after the motion or the response was filed. That doesn't look good. So let's build upon this and talk about the second strategy, which is not only to collect the puzzle pieces, but to put some of the puzzle pieces together during the deposition. And I typically do this with my car wreck cases. So the reason why I use this purpose and strategy with mainly car wrecks is because class actions are way more intense, and with car wrecks is typically to serve one primary purpose. So in a car wreck case, I'll usually, in a deposition, collect those puzzle pieces and then show those puzzle pieces kind of coming together. I probably won't show the entire picture, but a good portion of it. That way, the defendant kind of gets a sense of what's going to happen at trial. The lawyer kind of gets a sense of what's going to happen at trial. And the adjuster, the insurance adjuster behind the scenes, who's kind of the puppet master, gets a sense of how things are going to go at trial. And that's important. What I've realized with some car wreck cases, the reason why we're having the deposition at all is because the lawyer hasn't taken the time to look at the merits of the case, or the adjuster hasn't taken the time to look at the merits of the case. And the only way I can get them to focus on the merits of the case is to make sure everyone is sitting down. Granted, the adjuster is kind of behind the scenes and ends up getting the transcript, or at least like the shortened version from the defense lawyer saying, hey, here's what happened. It didn't go well. And that way people are finally starting to get on the same page. More often than not, it's that deposition that leads to a settlement that's favorable for my client. That's not me pitching. That's me just telling you the practical effect of having an amazing deposition. So the art of putting the puzzle pieces together is to typically show and get a sense to everyone how the trial is probably going to look in front of the jury. Make sure that you're not showcasing your entire case or playbook. Last thing you want to do is to show the entire playbook, and then the other side's like, well, we know what they're going to do, so let's go ahead and take our chances at trial by pivoting around this playbook to our advantage. The metaphor here is, if you're going to do the all-out blitz, then they may just run a quick little slant and then score with the touchdown. Actually never played football growing up, so I'm hoping that metaphor is applicable. If it's not, let me know in the comment section down below. So the point here is that if you're going to put some of the puzzle pieces together, then what you need to do is make a judgment call on how much you end up presenting to the other side. By showing the strengths of your client's case, by showing how it's going to look in front of the jury, and by showing the weaknesses of the other side. Again, use your judgment on what's going to apply and be best in your situation. Step number 3, create a character for yourself. So at this point in my career, there are 2 characters that I keep going back to because I keep having really good success with them. But unfortunately, this first character comes a little too easy to me. And this character is simply the clueless attorney. So the biggest benefit of playing the clueless attorney is that it makes the deposition, for the most part, relatively easy. And what I mean by that is you appear like you don't know what's going on. You appear like you're not really well prepared. You don't really have a sense of the story. And so you're basically just trying to get the story, get the version of events of what happened from the defendant in this situation. And so the defendant, and here's the big perk, is going to be more disarmed because they think they have the control. They think you're just here to listen to their side, their version of events. And so they're not being apprehensive with giving you information. In doing so, if you ask open-ended questions, if you kind of, heard the answers in a certain way to where you're, tapping it here, tapping it there to get the defendant to talk about certain topics, what they don't know is that they're actually backing themselves into a corner. And once they've backed themselves into that corner, you have to go back to your step number 2 determination, to where is the purpose to just collect information and then just call it a day? Or do you want to take things a step further, and do you want to show how the puzzle pieces don't really match up based on the story that the defendant in this situation just volunteered? But I will warn you, there is a downside with this character of playing the clueless attorney, which is that it is very difficult to make sure that you get what you need. Meaning, as you're asking questions and the defendant starts having some control of the flow of the answers, your topics are going to talk about stuff over here, over here, over here, over here. And so you have to mentally keep track of what all is going on. And we'll talk about that in a future step. But what's tricky here is that if you're going to put these puzzle pieces together in the deposition, then you're going to have to start referring to things that maybe happened 10 minutes ago, 20 minutes ago, 30 minutes ago, instead of immediately addressing the issue with that particular statement as soon as it's said. And so part of this is having to not only be willing to let go of the flow of thought that, really makes sense to everyone, but having to, branch off here, branch off there, to where beyond the script or outline that you've put together, everyone else from their perspective thinks that you're just all over the place with your questions. And in doing so, you need to maybe have a pen and pad nearby so you can maybe write down statements that are being made so you can eventually refer back to them when you start putting the puzzle pieces together. That's hands down the trickiest part with playing this character. If you decide to collect the puzzle pieces and then putting the puzzle together, but it's something that can be super effective because People really back themselves into a corner willingly and unknowingly. Now, the second character is a little bit more of a traditional character, and I like to call this one the quarterback. And the reason why I call it the quarterback is because whenever I take this role and I apply this character, I'm controlling the flow of the deposition, and I'm immediately pinpointing where I want certain aspects to be emphasized. For example, if the defendant at some point during this car wreck example says something that is going to help prove one of the elements, then I'm not going to wait too long before I circle back to it and flush out how that's going to satisfy an element or disprove an element if I decide to start putting some of the puzzle pieces together in the deposition. Let's contrast that with the clueless attorney earlier. The clueless attorney is going to wait at the very end in order to put it together. The reason for that is because the downside here with the quarterback approach is that as soon as the deponent, or in this situation, the defendant, gets the sense that their words may be used against them to weaken their case, they're going to clam up. They're going to be more defensive. They're going to be on their toes. And so you need to be strategic with when you use the quarterback approach. For me in particular, whether I play the clueless attorney or the quarterback, what I end up doing is always starting my depositions, asking open-ended questions, and being semi-clueless. So there's kind of like a hybrid approach. And then at some point with the quarterback approach, I don't wait till I go through all 100% of the questions that I want to get, but I'll find a sweet spot to where I feel like I have enough information in order to start pinning down the points I want to pin them on, knowing that any subsequent topics of conversation are going to meet more resistance. And so I strategically try and figure out where I want the resistance to be met, because that can actually be very beneficial. If the defendant starts clamming up and starts becoming defensive and saying, I don't know, well, maybe there's certain topics that I want her to say, I don't know. For example, I had a deposition where the allegation is that my client, the plaintiff in this car wreck, was speeding, and as a result, he was the one who was negligent. He's the one who caused all of his injuries. So knowing that she doesn't have any personal knowledge and is speculating on my client's speed, her best shot is potentially going to be hiring an expert to kind of figure out the math of, okay, if he was at point A and then ended up driving to point B in a certain amount of time, the equation works out to where he was traveling at a speed that was over the speed limit. That's her best shot. Knowing that, I decided, okay, the only way that expert, remember, we want to think 2-3 moves ahead. The only way that expert's going to have any type of credible expert testimony is if there's actual distances, locations, and times to do the math. And so knowing that the defendant was going to clam up after I started calling her out on certain violations or listing them, I knew that she, after becoming more defensive, would start defaulting to the I don't knows. And so at that stage, I strategically started asking questions about location. Oh, I don't know. And then time, I don't know. And then again, kind of in the negative, starting to take away the ability to have an expert, the ability to be able to make this allegation about speeding if she doesn't know any of that. This is a real life example that ended up taking place like a week ago or 2 weeks ago. And so it's really fresh on my mind. And if you want to see more of this example, I'll see if I can put this deposition together for you. Again, I'll link it once it's ready down below, so be sure to check it out. But this one in particular, I spent a lot of time on because there are a lot of different moving parts. It's a sizable case. And so it was all about trying to anticipate how a person psychologically would react to being called out and to ultimately admitting to certain violations, and then using that to the advantage to, again, quarterback the entire deposition, to have control and to be able to direct it where I wanted the deposition to go. So I recommend, whenever you're deciding the character, figure out how you want to handle it. If you feel like you can't really afford for the witness or the deponent or the defendant to clam up and become defensive at any point, then maybe you want to take the clueless attorney approach. If you feel like you need to be, kind of firm and give them a sense of how the trial cross-examination is going to go, and you want to be more pointed, then maybe the quarterback approach is going to work best for you. Again, figure out what's going to work best in your situation, in your case, and for your client. Step number 4 is to script out your deposition. And I'm talking line by line. Look, I'll be the first to admit and concede that with the law of entry videos, I don't script line by line on what I'm gonna say. I typically write little headers on the subject matters and the topics and then just kind of go from there. I'm sure a lot of my videos appear just like that, and the reason for that, and I hope they are semi-beneficial, but the reason why I try and keep it not scripted and more organic is because if I say something that makes me laugh at myself, not with myself, then I hope that seems organic and genuine instead of me saying, insert joke here, now laugh, ha ha ha. And side note, by the way, if you're just wanting to get straight back to the material, I would skip ahead maybe 30 seconds, but the law school professor that was hands down the oldest law school professor I had ended up sticking to a script that every student ended up having over the years. It just got like more accurate. And he stuck to that script down to the date that was on the script, to where we knew exactly the jokes that he was going to make on the particular day. So we knew exactly when to laugh if we weren't paying attention. It was just follow the script and then just had this like ha 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 laugh. And he thought he was killing it day in and day out. Okay, let's get back on topic talking about scripts. And the important part with your deposition script is that you want to line by line write it out, but as you'll come to find out, you don't, during the deposition, want to stick to your script religiously. Meaning, if you end up getting something that's very beneficial for your case, for your client, for elements, then flush that out and then just come back to your script. And so when I say script, the reason why I'm saying script is because that's what's going to make the most sense. But I just, at the end of the day, want your script to be more like a home base. There are numerous reasons why I think you need to be scripting out your deposition. First, once you have your script written out, and as you're going through it and reading it, you can get a feel for not only the pace of the deposition, but the potential tension of the deposition. If you're talking about subject matter that you know is going to make the defendant squirm, or you know the defense lawyer is going to start objecting to, then most likely that's going to set the tone for the rest of the deposition. And so you need to strategically figure out where the tension, if at all, needs to occur first, knowing that it's probably going to stay a little tense during the remaining portion of that deposition. Second, the script allows you to make sure that some of the most important questions you need to ask are absolutely bulletproof. What I mean by this is, as you're going line by line, you'll know the important questions, because those important questions are most likely going to have something to do with the elements we were talking about earlier. The elements that you're either trying to prove or disprove. And typically, the buzzwords and the phrases that are required in order to prove those elements are going to cause the defendant's ears to perk or the defense lawyer's ears to perk. And so there's a chance that there's a potential objection. There's a chance that the defendant may try and wiggle out of the question if there's a room, any type of room to wiggle out of it. So you want to make sure that is absolutely bulletproof. Make sure you're not using particular words that could be ambiguous, or any words that may be improper or that may lead to an objection of any sort. So again, if you're going line by line and you're trying to attack your own questions and you figure out, okay, this is the way I need to ask this question in order for it to be bulletproof, there is nothing wrong whenever it comes to game day and you're going through your deposition questions to say, okay, I need to make sure that this particular question is said this exact way. And then you go down and you basically read the question to the deponent, and the deponent has to answer that bulletproof question. Don't try and get too confident. Don't try and get too cocky to where it's like, I think this is how I worded the question. And then you say the question and then you use the word that was a little bit less ambiguous than you would have liked, or more ambiguous than you have liked. I got flipped there. And then as a result, whenever it comes time to maybe cross-examine the witness at trial, the witness says, oh, no, 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 no. When you said this word, I thought you meant this, not that. And the reason why that probably happened is because the defense lawyer heard the question, was like, oh no, this is not good. Let's talk about how we can get out of it. And then in doing so, that's how they get out of it, potentially. And as you're going through your questions, I want you to attack every single one of them. In doing so, figure out if there's an objection that's going to be raised, that's going to potentially make the question invalid, and also figure out what all possible answers are on the table whenever this question is asked and ultimately answered. Because if there's a worst case scenario answer that is on the table, that is out there, you need to know how to handle it. And sometimes those situations with a worst case scenario answer may cause you to go from script to, okay, maybe we have to detour a little bit in order to ultimately bring things back around and get back onto the script. Again, the script isn't something that you need to religiously stick to, but it's going to provide that home base for you to get back to. And if you have that type of criticism to your own questions to where you're really trying to pick it apart, think of these answers that could potentially complicate your own script, that's going to make you much more prepared. I lost count of the benefits of scripting, but this takes me to the next one, which is by having your script in that home base, that's going to provide you with some clarity on which exhibits need to be used as maybe a demonstrative or maybe as impeachment. But in general, by having the script, the goal here is that you'll be able to have some clarity on when exactly you'll be using particular exhibits, if at all. You don't want to bring every single exhibit to the deposition or have it ready on your laptop, fired up. Instead, you want to be able to keep the deposition as clean and as simple as possible. And so if you go through your script and realize, hey, I only really need like maybe 5 exhibits, then just bring 5 or maybe 6. We'll add an extra one to it in order to be extra cautious. I'm going to say this one again because it's important. Don't be religiously stuck to your script. If you get good information, then make sure that you flush it out, even if it takes you off script. Just be sure to come back to your home base and then keep moving forward. If something causes your ear to perk up a little bit, then that's probably something you need more information on. Don't worry about controlling every aspect of the deposition. Just do the best you can. But along those lines, and this is probably even more important, if you hear something that maybe sounds bad for your client, then you want to actually flush that out. Most likely, and I'm sure there's an exception out there somewhere, you most likely want to flush out the bad answer as well in order to get a potential sense of what the other side's going to try and spotlight during trial. If you hear something that is even remotely bad and then you stick to your script and you don't flush it out, then on direct examination during trial, that, let's say, defendant starts talking about it and you don't have any questions to cross-examine on other than maybe off-topic subject matter, and that's not going to be very helpful for that particular pain point that your client may end up facing. So flush it all out. Let the deposition be the ability to collect ammunition, but also let it be a way for you to get insights on what the other side may be focusing on. I also want to stress that the script that you're building and the questions that you're writing need to be dependent and determined by the character you ended up choosing earlier. Meaning that if you decide to take the, let's say, clueless attorney approach, then the questions that you should be writing should be more open-ended and should give a lot of leeway and range for the deponent to be able to kind of take the question where they want to take it. In that situation, as they're answering the questions, you may get 3 good facts or 3 things to inquire on in one particular answer. So it's your job to then have more open-ended questions to talk about each one, flesh that one out, another one, flesh that one out, another one, flesh that one out, then eventually come back to the home base and then keep going with your topics. So whenever I build my script for the clueless attorney, I'll try and have the overarching topics to where I can jump back and forth maybe from one topic to the next. So for example, if I'm going through a series of questions and let's say the defendant in this example decides to start talking about topic number 4, then at that point, I'm just going to say, okay, let's start asking questions about topic number 4 and then go through the script at topic number 4, knowing, okay, now I need to go back to topic number 2 at some point and then flesh that out. And so from the perspective of the people who are listening or the deponent, it seems like you're all over the place, but as long as you're sticking to that home base, that outline, you'll be good to go. But again, with the clueless attorney, you're keeping it open-ended. You're not asking too many leading questions, because a leading question is going to make someone more defensive. Simply saying yes or no to something is just inherently a little bit more adversarial, which then takes me to the quarterback approach. If you are taking that approach, then it's all about being more targeted, more strategic, kind of surgical to some degree, to where you're just pinpointing certain aspects. So in those situations, you are going to be asking leading questions a little bit more often. But just keep in mind, for my personal approach to things, whether I'm doing the clueless attorney or whether I'm taking the quarterback approach, at the beginning, I'm asking some degree of open-ended questions in order to get some ammunition for the quarterback to eventually use, or in the clueless attorney approach, if I decide to put the puzzle pieces together, for that all to happen. Step number 5, practice the presentation. This step is relatively simple, but I don't want you to overlook it, because if you end up not preparing the presentation, then you may end up being frazzled. You may not end up using exhibits that you probably should end up using. So the point here is that whenever you are preparing for your deposition, get comfortable with the exhibits, get comfortable with how you plan on introducing them. If it's a Zoom deposition, get comfortable with how Zoom works when it comes to sharing your screen, maybe marking using the Zoom cursor thing, and then ultimately saving the file so it can be added to the record. Or if you're doing an in-person deposition and there are a lot of exhibits, and make sure you know where the exhibit is if you have like a full binder of documents. You don't want to say, okay, now let me refer you to, one second, and then you're like looking, and you can't find it. Then you're just like, okay, anyways, moving on. And then you move on from something that probably was going to be important if you were already thinking about using that particular exhibit. Again, as you're going through your script in the previous step, that should give you a sense of the exhibits that you plan on using, but you need to take it a step further. You need to know how you're going to ultimately use them, and you need to also kind of have a sense on how you're going to cite to these particular exhibits. For example, you may say, okay, now we're looking at exhibit number 1 of defendant's deposition, and on page 3 of exhibit number 1 of defendant's deposition, we can see here on paragraph 2, this and this and that. That way, even if you don't have video, or even if you do have video, the record from the transcript is going to be ultra clear, and that's always a good thing. Okay, so this sums up the 5 steps that you need to take in order to prepare for your next deposition so you can go dominate that deposition. And like I said earlier at the beginning of this video, and I don't know if people watch the beginning of videos, the end of videos, if they just go straight in the middle to try and get the meat, but like I said at the beginning of the video, this particular lesson wasn't going to dive deep into the examples. I didn't really want to get you bogged down, just in case all these principles, all these abstract thoughts made sense and the examples ended up just being icing on the cake. I didn't want to slow you down here. I want you to be able to go through all these lessons as quickly as possible. But if you'd like to see some of the examples that I'm talking about, if you'd like to see these abstract thoughts and strategies and ideas implemented, then go into the body of this lesson and check out the courses once they're available. Assuming they're available by the time you're watching this, that's something you're not going to want to miss out on. And with all that said, if you have any questions, thoughts, concerns, or ideas, or just want to say hi, leave that in the comment section down below. If you're on YouTube, you're obviously a rule breaker, but I won't say no to a like down below. Obviously, I'll be super happy with you if you subscribe as well. And with all that said, I'll go ahead and see you in the next lesson.